Okay, here we are with the first presentation, the introduction to the EU timber regulation. In this presentation, we will be talking about the EUTR basics, basically what it's coming from, where does it exist, what does it cover. Then we will speak a little bit about the EUTR actors, so who's involved in the whole process. Then we will talk about the product scope, so which products are involved, which products fall under the scope of the EUTR and which don't. I'll briefly introduce due diligence, but as you've seen from the agenda, we'll have a full session on that after this session, so I won't go in too deep. And I'll also have a few words about EUTR enforcement, what is happening at the moment and how do we see it can still improve, and so on. So EUTR, European Union Timber Regulation, the main objective basically of this regulation is to prevent and to deny illegal timber into the European internal market, either coming from outside or from forests in the market itself. To do that, we have a regulation on EU level, which is then applicable or binding to the member states, you see here in yellow, and they have to then implement it into their own legislation and make it work, basically. I also want to say, so on this map, we have Norway and Iceland. They also have adopted EUTR timber regulation, and UK recently left the EU, but they also adopted a very similar legal instrument called EUTR for the moment. Maybe they'll change it. So basically, it's the whole of Europe that is implementing some form of timber regulation. Now for the EUTR itself, some dates. Also not going to go into every date here. It's just important to know that it entered into force 2013, so that's when the member states had to implement it. And then 2018 and 19 is maybe also worth mentioning some communication from the European Commission working towards further implementing, streamlining, and coordinating the whole EUTR, and also making it more visible or easy to understand for operators. So this is also basically where the idea for this live project starts, and the idea of helping implementation and enforcement throughout the member states, because we will see in future slides or during the day that there's not always a very coherent way of operating throughout the different member states. So that's definitely something that is important to work on, and important that it was acknowledged like that. Okay, EUTR actors, so who's involved in the whole thing? There are basically four big actors, or four big blocks. We'll mainly focus on two of them today. But we have, of course, the European Union and the Commission that formulates the regulation. Then we have the member states, together with their competent authorities that are enforcing and controlling EUTR. We have monitoring organizations that can develop a due diligence system, ensure its proper use, help operators and well, maybe even traders to implement and to control due diligence. And then, of course, at the heart of the whole mechanism, the EU timber industry, divided in operators and traders. We'll get into that later. We will focus mainly for now on member states and their competent authorities, and on the EU timber industry. So I won't be saying much more about the Commission and the monitoring organizations. Let's start off with member states and their competent authorities. Also, there is a more detailed presentation from the competent authority of Belgium on Friday. So let's say I'll just briefly introduce what they're doing basically. What has to happen, of course, when after the EU regulation, member states have to turn regulation into legislation, and then detail rules and penalties and so forth. What member states also have to do is they have to cooperate with each other, with the Commission, and with countries from outside. They can also provide guidance to operators in terms of guidance documents, or even disseminating reports or relevant information about cases of illegal logging, or if something comes to light, they can also disseminate it throughout for the operators in the country. They also check monitoring organizations and make a report of that. Send it every 2 years they send a report, or they make a report about their progress and their doings. And of course, importantly, a competent authority, one or various. We have seen, for example, in Spain, there are a lot of competent authorities for each province or each state. Other countries just have one organism that is the competent authority. Now, competent authorities, I mean, we will get more into detail what the actual role is there, but in big lines or in oversight, it's just they check operators to see if they are complying with the regulation. And this can be, of course, doing field audits or visits, or just via customs, via shipments, and could be based on, for example, sectors or focus on furniture, focus on import or so. Could be risk-based that they visit or audit a company. Like this is high risk, or they're importing from a high-risk country or a high-risk species, or high risk in volumes and so forth. Or it can be that they control operators on the basis of substantiated concerns by third parties through reports or through investigations that resulted in illegal logging or potential risks there. Also, the competent authorities have to keep records of their controls and of their checks. If you, of course, are found to be shortcoming, or there are irregularities found during this visit, it could mean seizure of your products. It could be that they advise you to take action, to change something in your due diligence system, to change or provide extra information. You could receive a fine, or even other penalties are available. So, yeah. Just to make sure that operators comply with regulation. Then on the other side, we have the operators and the traders that have to comply with the regulation. I'll show this one. This is a part of the previous picture, but then focused on the timber industry. The big player in here is, of course, the operator. When are you an operator? Of course, that question will come a bit later, more into detail. But basically, it means that when you are importing wood or wood-based products from outside the European Union into the European internal market, then you are basically the operator. And then you have to ensure that there is traceability. So you have to know where the wood is coming from. That's what you do through due diligence and so on. So more details on that later. And you, of course, have to make sure that the risk for these products that you are importing is low, and there's no high-risk material coming into the market, high risk for illegality. And then you have the traders. Traders that basically have to assure traceability to, like, who are they selling to, who are they buying from, so that it can be traced back to the operator, and from there it can be traced back to forests and country of origin. So those are two actors. Maybe you are operator for some products and trader for other products. It's perfectly possible. Maybe you are an operator for everything, or maybe you includes things in the scope that are not actually required by the EUTR, but you can still be an operator for everything then. For example, you can also be a trader like a sawmill. Normally you would say sawmill seems to be more like operator, but it could also be a trader if there is, for example, the forest management itself that does sales, or there is a broker in between, or an agent or so. So it could also be that a sawmill can be a trader. It's not always very clear on just the organization's activity. Yeah. So importer is when you, of course, import the goods into the European Union. The definition, I mean, it's independent of ownership or other contractual arrangements, which means it's not necessarily the owner that has to be the operator, but in general, we can say that if you are the consignee on the import document, then you are considered the importer and thus the operator for the goods that are coming in. I hope that's a bit clear. Otherwise, we'll talk about, when we talk about the scope or the products that are involved, it will also become maybe more clear if you are operator or not under the EUTR. Now we have a first poll. Okay, hang on. I'll try to launch it and see. Hope everything goes well. So this basically, the question is coming up to ask if you are an operator or a trader, or you don't know, or you export or so. Let me, oh no, I think it's this one. I have to launch it, sorry. First poll of the day. Yes. So now, in theory, you can answer this poll. Click on some questions. Just one, I think you can choose in this one. Okay, I see votes coming in. I'll leave it a bit, maybe until we reach like 70 or 75% of the voters. And then I'll present the results. So now already 60% of the attendees voted. I'll leave it a bit more. It's neck and neck. I'll show it later. I think it's just clicking. I don't know really how it works. I only know this side, but I think it's rather obvious. Okay, almost 80%. So I'll leave just 10 seconds more, and then I'll close it. Yeah, okay, let's close it. Then I'll share the results really close. We've got a bit of everything. As you can see, mainly operators in the room or in attendance, and also a lot of traders and some other organizations, I guess. Okay, that's for the first poll. I hope it keeps you on your toes, I hope. Okay, so if you are an operator or you identified yourself as an operator, what do you have to do then? You basically have to have two obligations. They'll return during the day, but they are important that you understand that there are basically two aspects of being an operator. And the first one, of course, is the result. You have to make sure that no illegally harvested timber or timber products are placed on the market. So that's basically the goal and the result of what you have to do. But then also you have an obligation to exercise due diligence, due care, like Chloe said, through procedures and measures and all kinds of procedures that you can implement in your company. And you have to evaluate and keep it up to date, this due diligence system. And that's the obligation of means. So you are, even though you don't have anything illegal coming in, you still have to have due diligence and a due diligence system, and have to be able to demonstrate how it works and how you make it work, and how it forms a system. All that, of course, to, again, prevent illegally harvested timber or timber products coming in. So illegally harvested timber and due diligence will be two aspects that we'll talk about later in more detail, and talk a little bit about the definition of each of those concepts. But as an operator, those are the main things that you have to worry about. Traders also have obligations, so not so difficult, of course, but still they have to be able to identify their suppliers and their buyers, except if you're the last retailer or you sell to the end customer. But you have to have traceability. You have to demonstrate that you are able to trace your product. You have to keep your information for 5 years, and if the competent authorities ask for information, you are also obliged to provide it. But other than that, you're relatively safe as if you are a trader. Yeah, here it is again, but in a more visual representation. So products coming in, the first actor is going to be the operator, who has to trace the timber to the country of origin and has to have the due diligence system to avoid illegal timber. And then the trader and traders further up in the supply chain, they have to maintain traceability. Okay, now let's talk about what products are in the scope of the EUTR. Mainly, so EUTR says timber and timber products. So basically anything containing paper, cardboard, wood fiber, or wood is included in the scope of the EUTR. There's a complete list of custom codes, so it goes based on the custom code. In the annex of the EUTR, there is a complete list of codes that are included. Some exceptions are made. For in here, basically, it's mainly if you have any goods that are at the end of their life cycle and are otherwise discarded as waste, that could be recycled into something else. Then you have a wood product or a wood fiber product that is not under the scope of the EUTR. I'll also reiterate that it's important, or that you can, of course, include in your due diligence system products that don't fall necessarily under the scope of the EUTR, but you can still do due diligence or include them in your system if, for example, you want to make sure that also other products are complying with legality requirements. And I'll also advance on a question that we probably get here on this slide, or regarding the scope. There are a bit of weird exceptions to the scope that I'll list in the next slide. But there has been a lot of comments on why are they not in there, and why doesn't the scope change. Just to say that there was an impact assessment in 2018, I think, from the EU or the Commission to talk about changes into the EUTR scope, and stakeholders were able to provide information, but that's more or less where we left the situation. We don't have any more information on that, but I think it's safe to say that the scope will expand, and the legislation is in the process of expanding, so probably more and more products will be added to the scope, and maybe even other commodities that have forest impact will also be included, or could also be included. So for the future, maybe we'll probably get a wider scope. Now onto the exceptions. Waste products, like I already said. Seats, so anything that is wooden furniture, but sofas, and chairs and so on are exempt. So also one of those weird scope issues. Packaging material is a bit of question mark as well, because if you are, for example, buy a disassembled furniture in a wooden box, the wooden box doesn't have to comply. But if you're buying crates or cardboard boxes to be used as packing material, just for the packing material, then they are included in scope. A bit the same for printing materials. A book or something that is where the essential character is not the printed material but what's printed on it. So a book doesn't fall under the scope, but printed, I don't know, toilet paper or notebooks, they fall under the scope of the EUTR. So it's not always very clear. Musical instruments also not. Toys and games also not under the scope. So also one of those issues that provoked the scope discussion. Bamboo is also out, and then handles and brooms and tools also out, but probably will be included in the future, or it would be logic to include it. Of course, in case of doubt, look at the custom codes. So don't say, oh, this is probably printed material or whatever. Look at the custom code you import it with, and then you can see, okay, it's not on the list or of the scope, or it's on the list of exemptions, and then that way you can be sure. Introduction to due diligence. So we're going to start off again with a poll, and this time the question will be, do you know what due diligence is? No idea, a vague idea, or I know exactly what it is. I'm gonna launch it, I think now. Launching, yes. So again, give us your answer. I'll leave it open for like a minute and a half or until we reach 80%. And then I'll share the results. All right, everybody's voting very, very fast, 75%. I'll leave it just 10 more seconds. Okay, 80%. Let's share the results. So 51% knows exactly what it means, due diligence, so that's actually good. But it's also good to see some vaguely or some that don't have an idea. This is the exact place to be then. And I don't know, it would maybe be nice to do this poll again at the end of Friday and then see if we have improvement. Okay. I'm hiding. Okay, let's go at it. What is due diligence? This is just, I mean, I've got two definitions here. 1, 2. Operators are required to exercise due diligence, as we already saw earlier, and they have to use a framework of procedures and measures to do so. So you have to make care that you investigate, let's say, products from coming into the European market, and you have to use a system for that. You have to document it, because otherwise it's probably not going to be systematic, and it has to be a step-by-step method. And the steps that are included in the due diligence will be discussed in a few slides. Okay, so we already talked about it. It has to be a system. What is the objective of this system? Basically, you have to evaluate and mitigate risk of something being illegally harvested. Something, I mean, wood and wood timber-related products. but you have to assess the risks of putting something illegally harvested on the market. Yeah, that's the whole idea of the EUTR, of course. Risk and illegality will be discussed in the next slide. The steps that you have to investigate will also be discussed. But just to make sure, like on this slide, you basically have everything. But we will go into detail into the concepts of these parts. So risk, what's risk? Difficult to answer in one question, in one sentence. Just a reminder, risk and illegality are at the heart of the due diligence system. That's what ETR is all about. So the risk of illegality in this case is the likelihood that a legal obligation is not enforced. So there has to be a legal obligation first for it not to be enforced, for it to be illegal. Of course, we won't be looking at every kind of risk, but we will be looking at forest level risks, supply chain risks, and risks of mixing. Forest level, of course, what's happening on the ground, are the documents okay, is there harvesting permits, so on. Supply chain risks, everything that goes from the forest to when you get the material, are there legal obligations that are broken or violated or enforced or neglected? And then risk of mixing, contamination, it's very important because you can do due diligence on maybe one wood species and then find you have two more in your product that you didn't know about, rendering basically your first assessment invalid or incomplete. We speak about low risk, but not about no risk. There's always a bit of risk for something to happen. I mean, you can always fall going out on the streets and die or break your neck. But the risks of that are, of course, low. And then we speak about negligible and non-negligible risk because there's no intermediate. I mean, there's either a risk or there is no risk, or the risk is very low. Legal and illegal timber is a bit more complicated because we don't have, unfortunately, we don't have an internationally agreed definition that all countries adhere to that says illegally harvested timber looks like this. Instead, we have to rely on legislation in each country of harvest. And this, of course, provides difficulties that there are maybe 100 countries where you can import wood from, so that's 100 legislations that you have to be aware of, which is, of course, could become very difficult to investigate. Luckily, we can apply our search on only 5 specific areas for legislation, and that's the ones that are described in the EUTR itself. We'll see them a lot during the day and probably on Friday as well, but I'll state them here. Rights to harvest, which is basically legally harvesting timber. Are you allowed to cut there? Are you allowed to cut that quantities? And so on. Payment of the harvest rights and timber duties, taxes, everything. Timber harvesting, that's then the harvesting activity itself. Environmental legislation, management, diversity, and everything related to, for example, safety and health and safety and so on. Third parties' legal rights concerning use and tenure that are affected by timber harvesting from local communities or tribes or any third party that has legal rights in that area or in that country. And trade and customs, everything that goes from paying taxes to safe havens to import documents and so on. So on these 5 topics, you have to be aware of the legislation in the country of harvest and then assess the risk of it being enforced or not enforced or broken. And that's why you use, or that's why you have to implement due diligence. And the steps of due diligence are as follows, or are also described in the ETR. Three main steps, of course, as access to information, risk assessment, and risk mitigation. That's basically the core of due diligence. Access to information, you obtain information from your supplier or their supplier or the forest level about the shipment or the things that you are trying to import. Risk assessment, you evaluate the risk then of is it going to be illegally harvested, or is there a risk of it being of any of the legislations being violated or broken? And then you have to mitigate it by doing actions that lessen the risk. So for example, if you take this guy here crossing the street, he either didn't have access to information, like he's maybe blind and deaf. He either didn't do his risk assessment, like he doesn't know that a car that hits you can kill you, or risk mitigation, he probably thinks he's fast enough or he can dodge cars or something. And this is basically an important slide. I guess Chloe in the next presentation will also talk about it, but don't see due diligence as linear, going from access to information, to risk assessment, to mitigation, to low risk. See it as a continuous process, going from one to the other. You get information, you assess risk, you say, oh, maybe information is missing, you go back to requesting information. Then you say, oh, we have a risk here, we can mitigate it by doing this, but then it goes back to the assessment where you maybe need another piece of information, or you do some other measures. And it goes back and forth until you reach a low conclusion on the risk assessment. And this is very important for everybody. You have to have low risk conclusion before you start putting something on the market, because otherwise you're not complying with the EU timber regulations goals, which is avoid putting illegally harvested timber on the market. So if you do it afterwards, you already put it on the market. So that's not in the spirit of the EUTR. So always do this process before starting to work with a supplier or supply chain, or before at least starting to put it on the market. Okay, elements of the due diligence system. So what should be, apart from doing all these tasks, should also be in the system, or what forms your due diligence system? And it's basically everything that you implement, procedures, work instructions, tools. You write down how you do it, who does it, who's responsible, when do you do it, how many times. All of this will form your due diligence system. So it's not just one piece of paper or one document. You say, this is our due diligence system. It has a bit of everything, and it has to cover the steps that we saw earlier. And for it to be efficient and robust, you have to have, it's not really super like what is written in EUTR, but it's what is logical coming from the demand of the due diligence system, is that you have a solid commitment from the organization in form of, for example, a policy signed by the executive level, stating that you are committed to doing due diligence, to not having illegal timber in your supply chains, and so on. And then you can publish it or send it to suppliers to let them know you're serious. Then, of course, you have to have clear responsibilities designed, who's going to do what, when, and how. And then, of course, you have to have staff that knows what they have to do. So that's very important as well. Best, of course, is to have it in written procedures for clarity and continuity. Yeah, it's best to just have it written down, because normally if you just have one person working on EUTR and then he quits the job or he goes somewhere else or something happens to him and nobody's aware of it, at least when you have document procedures, you can basically read them, follow them, and you should be able to continue with doing due diligence and avoiding risky situations. Also very important, and something that has to be done, is you have to keep it up to date. You have to control it and see if you are still doing the correct things, if you should change something, because we all know supply chains are constantly evolving, suppliers are changing, situations are changing, even legislation is changing. So you really have to keep your system up to date. You can do internal audits, external, hire somebody to review it, work with a monitoring organization, and so forth. But it has to be a part of your system. Very important. So you have two obligations, as we said earlier, in the face of the EUTR. One is avoiding illegally harvested timber products. And the second one was having a robust due diligence system. So if you don't have that, you could also be sanctioned by the competent authority. It's very important to know. Okay, EUTR enforcement. We've got another poll coming up. Let me get that. So the question here basically is going to be, have you had any controls yet by the competent authority of your country? So those outside Belgium, just think about your CA, of course. I'll let it run a bit. Fast photos, that's nice. I'll let it run for 10 seconds more. We've got 75% that voted already. Okay, let's close it down and share results. So yes, 46% already has had a visit of the competent authority. 34% that didn't have any, so and then 20 that I'm not sure. So yeah, I mean 50-50 that you have had a visit or not. Okay. So yeah, the details or the specifics about enforcement in Belgium will be handled in the second day. But just quickly, what are the possibilities or what is going on with this enforcement? You are liable to prosecution and penalties because it's legislation. So it can be, you can break it or you can be in violation of it. Sanctions, as described in the EUTR, shall be effective, proportionate, and have a deterrent effect. So not disproportionate, but still have a deterring effect so that it won't happen again. And then you can have, of course, depending how it is written in national law, several sanctions possible. We already talked about that. You can have fines, they can confiscate your stuff. Suspend your trade, ask for actions, even imprisonment. I don't know if anybody got imprisoned for this yet, but it's a possibility. Now some comments or maybe some reflections on it. What we see or what is happening is that there is very inconsistent enforcement throughout the member states. Some are doing a lot of controls, some countries, some others are not. Some are really strict and fine you for just having small details missing. Others allow a lot. So this is also in the spirit of this webinar and of the LIFE project, something that we want to streamline, let's say. What is true, or in general, we see inspections are growing in general, so more and more companies are getting controlled by their competent authorities, so that's a good thing. On the other hand, there's not a lot of transparency for us to see what kind of cases or the information of cases of enforcement, or what is happening there, how are they resolved, why were they there in the first place, and so on. So that's something that can improve, and that we would like to see improves. There are some reports like in the World Conservation Monitoring Center and so on, but not every CA is making the same kind of report. It's not really consistent and not really transparent. So maybe the CA can shed some light on how they do that in the second day, but then it would still be a case of having to streamline between all the member states that they do it in the same way. Where do we see like most cases of sanctions or most cases of conflict? And that's normally when there are some substantiated concerns. So for example, if there's an NGO report regarding a supplier or an area in a country, and then trade operators are sourcing from that country or from that area or from that supplier, then we see a lot of activity and a lot of sanctions that are happening. Companies importing from high-profile countries also have more probability of control and also more probability of being in violation of the regulation. So that's also, of course, something that you have to keep in mind. And then, important, I already said it before, I'll say it again, if you don't have due diligence system, or if it's not robust enough, you can also, or a lot of companies are experiencing or are getting sanctioned for just the fact that they don't have a decent due diligence system, even though they're not sourcing anything from suspicious countries or high-risk sources or whatever. But just the fact that you don't have a due diligence system could be cause for sanction alone.